All right, call. Well, that's okay.
We're trying to confuse y'all.
Yeah, we're trying. Call the case, please.
Dover Signature Properties, Inc. versus Customer Service Electric Supply, Inc.
Good morning, Your Honors. I'm Bill Reeves here for Dover Signature Properties, Inc., the appellant. I can at least remember my own name, so good start.
Promise to start.
This case has
You want to reserve any time for rebuttal?
Yes, 5 minutes, Your Honor.
All right, thank you.
This case has been pretty well briefed, so what I want to do is focus on first the exhibits, which I think are largely dispositive, and then some of the testimony presented at trial. The record is voluminous because there were other issues resolved before trial, but this is about a trial that was a half day, one witness, 9 exhibits admitted in evidence. The issue overall is whether a joint check agreement is enforceable. There were 3 parties purportedly to it. Dover Signature Properties, Dover, the owner general contractor, Rutledge Pike Electric Company, which was Dover's subcontractor doing the electrical work on the project, and Customer Service CSES, the appellee, which was a material supplier to Rutledge Pike. And prior to the issue about a joint check agreement, clearly Dover had a contract with the subcontractor. Clearly, the subcontractor had a supply agreement for this project and others with the appellee CSES. So the purpose of the joint check agreement, among other things, would be to modify those 2 agreements. We, of course, submit that there was never an agreement formed. And secondly, even if somehow you would find that there was an agreement formed, that performance was waived by lack of activity by both the appellee, CSES, the supplier, and by the subcontractor. Neither one of them did anything to perform after the agreement was purportedly signed, other than continue doing what they had been doing. Nothing changed at all by any party. So what I'd like to do first is call the court's attention to exhibit number 6. And this is a email chain dated March 22nd, 2016. It's at page, it's volume 16 and begins at page 84 through 87 of the record. Looking at page 85 of the record of volume 16, it begins with an email from an employee at the subcontractor. Her name is Terry Borchert, and she sends an email to Dover, and it's addressed Jack/Kim. Those are both Dover employees. And it says, I have attached a joint check agreement to be executed and sent back to me for the switchgear package. If you need anything, please feel free to let me know. And that's at 10:52 a.m. on March 21. On March 22 at 1:58 p.m., Kim, who's the Dover employee, comptroller, responds and says, attached is document. Please forward complete copy as soon as all signatures are collected. The next page, second next page after that, is the attachment of the joint check agreement, which has been signed. It's hard to read the signature, but that's Kim, comptroller of Dover, that has signed it and dated it March 22nd. You see in looking at this exhibit that none of the other parties have signed it at this point. So in essence, Dover responded to this request, whether they would approve a joint agreement, with the offer, yes, we will, but send us back a signed copy so we will know that it's been completed. I would next look at Exhibit 5, again, volume 16 of the record, and that's at pages 79 through 83 of the volume 16. And Exhibit 5 is an email the same day from Greg Hedrick, who is the owner and president, principal of the Applee CSES. And he says, and it's an email addressed back to the electrical subcontractor at 4:06 p.m., just a couple hours later. He says, and it's addressed to Leonard Pruitt, who was an employee at Rutledge Pike Electrical, the subcontractor. It says, Leonard, the attachment includes the joint check form with my signature for your records. It also includes the current statement and invoices for this project. Please forward to Dover to ask for payment to get the account current. And the attachment to that email is where we first see that the other two parties have signed the agreement. So that all occurred on that one day, March 22nd in 2016. Also attached to Mr. Hedrick's email are 3 invoices which were past due, owed by Rutledge Pike Electric to the supplier of the Applee. We later learned, of course, that the subcontractor Rutledge Pike owed over $300,000 already to the Applee at the time this started. Now I want to turn to Exhibit 8 in the record.
Mr. Reeves, I thought what I heard you say in your opening was that nobody did what they said they were going to do under this agreement.
Right.
And but I'm not sure that I understand that argument with regard to the Applee. The agreement essentially, I acknowledge, is a 3-part agreement, but the requirements under the agreement essentially with regard to the invoices and whatnot, and between CSES and the subcontractor, it says the aforesaid parties, this is Exhibit 1, the
Yes.
joint check agreement, the aforesaid parties agree that any invoice hereunder submitted by CSES to subcontractor covering materials purchased for use on the project known as blah, 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 shall be paid within CSS's standard payment, whatever, by this negotiable check. As I read that, the invoices were to be sent by CSES to Rutledge. There's no requirement in the language of this agreement that I see that says that the invoices are to be sent by CSES to Dover. And then it goes on to say that in the exact total of such unpaid invoices shall be paid by the prime contractor. The sole purpose of this agreement is to provide for payment of invoices submitted by CSES on its sale of materials to subcontractor for use in this project. There's nothing there. I don't see any requirement in there that those invoices be sent by CSES to Dover. It appears that it runs 3 different ways as far as the joint check is concerned, but as far as the responsibilities between the parties, it appears that it runs between the parties who made the contracts with each other.
Well, I agree. First, there is no express language in Exhibit 1 that says CSES has to send, or that Rutledge Pike has to send the invoice. But think
There's
about...
no requirement that not has to send it all?
I agree, but how else would a general contractor pay an invoice according to its terms in the exact amount of the invoice unless someone gave them the invoice?
Well,
that's an implied condition.
That's what I'm saying. That's between the prime contractor and the subcontractor, but there's no requirement in this agreement, which is what we're dealing with here, that requires that. But I mean, common sense, is that it's between the two parties that made the contract with each other, which is the prime contractor and the subcontractor. The subcontractor had the invoices. I mean, between those two parties, why they didn't do what perhaps they should have done, I can't explain, but.
Well, I think, and I was trying to approach this time sequentially, and I was going to get to that, but I think the obvious answer there is the subcontractor didn't want a joint check agreement. The subcontractor was misleading the material supplier by saying, yeah, they've signed it, but we're not going to give them the invoices so they can pay by joint check. We're also not going to return the signed document to them so that they won't know that there's a joint check agreement. Also, the subcontractor, as part of its scheme, if that's not too big a word, continued billing on progress payments exactly as it had been doing for 3 months.
However, Rutledge did send pay statements to Dover that set out itemized statements stating what the pay statements were for, including this switchgear equipment, which was the materials that were being purchased.
That's Exhibit 9, and those progress payments were sent, but they did not mention CSES's invoices. If you look at the numbers, if you compare the numbers in Exhibit 9, which were the progress payment requests from the sub to Dover, first, it says that they've paid all that they're supposed to pay, and the numbers are percentages of the overall contract, and that's the way it works in construction. The percentage of completion is how they calculate the pay request. It's not related in any way to the exact amount of invoices generated by the supplier. So again, there's no way for Dover to know that anybody's asking him to pay a joint check in the exact amount and on the same terms as the invoices of the supplier.
Well,
It's just not there.
They could have asked for copies of the invoices.
Anybody could have asked. but
No. Between the prime contractor and the subcontractor who's submitting the statement that has an amount in there for specific materials, and your client who knows they've signed a joint check agreement in which the language of the agreement says that the invoices are being sent to the sub.
If I may disagree slightly, they know they've signed a form with no other signatures. They were never informed that the other two parties had signed it. So to say they could have requested invoices, well, yeah, they could have, I guess.
Well, they were the party to be charged on the joint check agreement, weren't they?
Well, it's a three-party agreement. Either of the other parties could have sent the invoices to be paid by Dover, but neither of them did. If I'm expected to pay a bill according to an agreement, and you don't send me the bill, then the duty to pay it never arises. It never occurs. And, in the context of construction, everybody's busy. The comptroller who said, send me back a signed copy, never got it. She never even thought about there being a joint check requirement, particularly when you continue getting, and I'll jump ahead to that in Exhibit 9. Let's look at pay application number 4, which begins at page 113 of volume 16. The numbers there that they're requesting payment for include wall ceiling rough, switchgear equipment, materials presently stored. Those numbers don't match the CSES invoices at all. There's no way to divine from that to issue a joint check. And again, this is the same process that had been in place between the general and the sub from the beginning. They never changed. They misled us as well as them, if you want to put it that way, by not telling us there was a joint check agreement. We had the right to be notified that it had been accepted. We requested specifically to be told that the others had signed it. And the record is clear, we were not told that it had been signed. We were not told to issue checks in the exact amount of the CSES invoices. And that continued. Pay application number 4 is dated April 4. That's about 2 weeks and 2 days after March 22nd. So what's going on? And you'll notice, if you look at these documents carefully, they're either signed by or notarized by the same Terry Borchert at Rutledge Pike, who had originally requested it and not returned it. So the proof is in the record also that because Rutledge Pike was in financial difficulty or financial arrears with CSES, that CSES understood that taking the joint check agreement funds directly from Dover, which is what would have happened, would have been damaging to Rutledge Pike. That's the context of what's really going on here. Dover is not expected to pay any more than they were already obligated to pay. They were just supposed to pay it differently. And paying it differently means, or would have meant, that the subcontractor was deprived of that amount of the cash flow.
Counsel, your time's up, but let me ask you a question here. Does it all turn eventually on whether or not your client who signed the agreement is going to be held to it, or whether they're excused from it because they weren't returned, as they requested, a copy executed by the other two parties?
I think, yes, they were not. We had the right to be notified that the other parties had accepted it. Mutuality of assent, mutuality of acceptance. We were not notified it had been accepted. In order to accept it, we would have had to modify our arrangement with the sub, and as I just went through, deprive them of the claim is some $90,000 of cash flow. Dover paid 3 payments after March 22nd on these applications from the subcontractor. Dover, there's no unearned benefit here. There's no unjust enrichment. Dover paid $112,289 after March 22nd.
Right, but you're answering my question, and basically is yes.
Well,
and I don't want you to make the argument, and I don't know what you're saying, but if the contract, you're saying the 3-party agreement is simply not enforceable against your contract, against your client, because they requested that they be furnished a copy of it as soon as it was executed by the other two parties. And since they weren't furnished a copy.
yes, that's the first offense. And what that really says is it's a 3-party agreement that must be accepted and performed by all 3 parties.
Okay. All right. You've used your time. You have your time for rebuttal.
Thank you.
Thank you. We'll hear from the appellee.
Good morning, Your Honors.
Good morning.
I'm Frederick Conrad, Jr. I am the attorney for the appellee Customer Service Electric Supply, frequently referred to as CSES in the proceedings and in the documents. In March of 2016, CSES had a problem with one of their customers, Rutledge Pike Electric, that they had gotten severely behind on paying their invoices. They advised Rutledge Pike Electric that they would not sell them anything further unless they had a joint check agreement with the general contractor, In this case, that was Dover, was the appellant. On March 22nd, they supplied a blank joint check agreement for Rutledge Pike Electric to have signed by Dover. It was returned to them on March 22nd with both the signature of Kim Hodge, controller of Dover, as well as Rutledge Pike Electric. They then signed that joint check agreement and returned it to Rutledge Pike Electric. They then, after receiving the joint check agreement, supplied the materials that were being requested. They invoiced Rutledge Pike Electric for those materials. They did not receive payments. In June of that same year, 2016, they informed Rutledge Pike Electric they were not going to be supplying any more materials until they got paid. In August of 2016, they sent a notice of non-payment to Dover, and subsequently Dover filed a notice of completion, and they responded to the notice of completion. With the notice of non-payment, they also filed a lien. This litigation started with an action by Dover on that lien. The court found that there were flaws with the lien that Customer Service Electric had filed and ordered that the lien be released. In response to the pleadings asking for the lien to be released, Customer Service Electric filed a counterclaim asking for the amount of funds that they should have been paid on the invoices that were supplied subsequent to the joint check agreement. The parties have agreed that that sum of money subsequent to the joint check agreement is $88,990.22, which is also what the court found that Customer Service Electric was entitled to receive. In the litigation, Dover originally denied that there was a joint check agreement, denied that they had seen the joint check agreement, denied that they knew anything about Customer Service Electric, denied that they had ever heard of Customer Service Electric. In fact, they continued to deny that they knew anything about Customer Service Electric until they found the lien, up through the litigation before the court, before this court right now. They make that statement in their arguments. They also denied receiving materials. They denied that the materials were incorporated into their project. They denied receiving the notice of non-payment. Through motions to compel, through discovery, eventually Dover did admit that yes, we did see the joint check agreement. Yes, it was signed by our controller. Yes, they were authorized to sign that joint check agreement. They continued to deny that they knew anything about Customer Service Electric, despite the fact that Customer Service Electric's name is on the joint check agreement. Counsel has already demonstrated to the court that there were emails regarding this joint check agreement that Dover was aware of. Eventually, they also admitted that all the materials involved were incorporated into Dover's project. Again, that required a number of pieces of discovery. Further along, they finally admitted that yes, they had received the notice of non-payment, that it was received by certified mail and had been signed for by Laurie Dover, who at some points is called Dover's president, although Rick Dover is also sometimes called Dover's president. It was not ever clarified as to who really was the president, or perhaps they were presidents at different times. So they start off saying that they know nothing about SES. They know nothing about this joint check agreement. They know nothing about these materials. They know nothing about this notice of non-payment. And every single step of the way, they eventually say, oh, yes, we do. Yes, these things are true. Now they're holding forth that they did not receive the joint check agreement back signed. However, there is no proof in this record whatsoever that they didn't receive this joint check agreement. They put on no proof at trial that they didn't receive this joint
Did they
check agreement.
testify they didn't receive it?
Excuse me?
Did they testify that they didn't receive it?
No, well, except through affidavit. They didn't testify at all at the trial. They put on no evidence whatsoever at the trial. So there's no evidence before the court that they didn't receive this. In fact, there is an indication from an individual at Rutledge Pike Electric that they did send the signed document. However, we did not send it. We could not present any evidence at trial that it was sent, and Rutledge Pike was not there at the trial to testify. So there's no valid proof before this court that that document was indeed sent, although there is in the record several indications about what Rutledge Pike claimed to have sent. I would like to address an item that's in the response of appellant to appellee's brief, because obviously I did not have a chance to respond to it since it was a response to our reply. And that is that they state that it's clear that the appellee instructed its customer, Rutledge Pike Electric, to return and execute a copy of the joint check agreement, and they go on to say that the proof is undisputed that this was not done. That's not true. It's not undisputed that this was not done. And then they cite the trial record, volume 15, page 94, lines 2 through 18. But what they are citing is merely the judge from the bench making arguments and asking me to respond to those arguments so that they can understand fully what our position is. In fact, the court goes on later, just a few pages later, at page 105 of the transcript, and states, "This is just argument. I'm just throwing this out, trying to get the best replies as I can. Not agreement with what I'm saying, not agreement with what I say or anything like that, just the best arguments I can get by pushing the other inquiry." The court is specifically saying, I'm not making these findings of fact. And in fact, when the court puts down its order, it doesn't make those findings of fact. It doesn't make a finding of fact that it wasn't supplied. It makes a finding of fact that even if it wasn't supplied, that's not grounds to set aside this contract. The situation is,
There was no proof that it wasn't supplied?
I'm sorry,
There was no proof that it wasn't supplied?
there's no proof that it wasn't supplied.
There was a trial
There was a trial.
with, and you're saying there's nothing in the record from Dover saying that they never received the executed copy of this three-party agreement?
That's correct. There is cross-examination of CSES's witness that he does not know for a fact it was sent, that he didn't send it to them. But there's no evidence before the court that it wasn't received.
Okay.
So we have a situation where it is acknowledged how much was on invoices after the joint check agreement.
Let me ask you one question about that.
Certainly.
In the court's order of November 19, 2021, the court in the order says the parties agreed that the sum of $88,990.22 was the correct total balance of the invoices the court found should have been paid by joint checks. Was that an agreed amount?
Yes, well, it was agreed. The court made a finding saying all invoices after this date would come under the joint check agreement. And the parties agreed that the invoices after that date totaled that amount. That's what the parties agreed to.
So it was agreed that those invoices totaled that amount.
That's correct. In short, Your Honors, Dover has consistently made statements to the court below and to this court that are inaccurate. They've repeatedly made statements that they should have known on the face were inaccurate. They were given a copy of the joint check agreement with the countercomplaint, and yet they denied the existence of that joint check agreement. They denied they signed it. They have the document right in front of them with the countercomplaint. They have to be making this conscious decision to lie to the court. Now, how they thought they were going to get away with it, I don't have an explanation for. But they have consistently lied to the court about what they received and what they knew about. They said they didn't get the joint check agreement, then they acknowledged they did. They said they didn't get the notice of non-payment, then they had to admit they did because we had a signature of Lori Dover on a certified letter sending them that. And then they acknowledged that, yes, they did receive the notice of non-payment. Now they're claiming, well, we didn't receive this thing signed, but they put on no proof in the trial court below. And even if they didn't receive it, it was not a condition precedent to make this contract valid. There was nothing that they put in the contract that said, this is not valid until we receive this signed contract. That was on an email where they sent the joint check agreement back. It is clear that CSES, from the trial testimony, would not have delivered this material until they had the joint check agreement. They signed the document, they sent it back. CSES clearly supplied the materials. They've acknowledged that now. And CSES was not paid. They don't claim that they were paid. And the amount that's in question has been agreed upon as determined by the court. For all these reasons, we believe the trial court's reasoning and decision below should be upheld. If you don't have any other questions, I'm through.
I hear none. Thank you. Hear from the appellant. Rebuttal.
Yes, to clarify about the trial, this trial was about the enforceability of that joint check agreement, not about the prior discovery disputes. None of that is in this record. Secondly, the burden is on CSES to enforce the agreement. At page 90 of the transcript, is discussed between the court and counsel. And the court says, and this is page 90, line 14, but this never gets communicated back to Dover that CSES signed it. Mr. Conrad says, is there any evidence that it didn't get communicated back to Dover? The court, well, they don't have the burden of that. You have the burden of showing that it did, and I don't have that. So the burden about the delivery of the fully signed agreement was on them, and no evidence was presented that it was. They could have called someone from Rutledge Pike if they wanted to, and they did not. They did not have any evidence from their own witness about it. So at the end of this one witness's proof and the introduction of these 9 exhibits, we moved to dismiss. The court took it under advisement, and we chose not to put on any further evidence because there had been no evidence of a signed agreement being communicated back to Dover. There is evidence in the record, principally in Exhibit 9, about the continued course of conduct between Dover and the sub, that things continued exactly as they had been. So I want to finish by reading from the transcript, the testimony that I listed and the court listed from the CSES representative, Mr. Hedrick. And this is at page 56, it's volume 15, page 56, beginning at line 4. Question by me to Mr. Hedrick. And yet you entrusted him, meaning Rutledge, to be the one to deliver a joint check agreement and to get Dover to pay it to you. You entrusted him with all that. Answer, yes, sir. Question, you didn't entrust anyone else to do that, did you? Answer, no, sir. Question, so when you sent that email on March 22nd that said get these paid and they didn't get paid, what did you do? Answer, we didn't follow up. Question, and when you sent whatever invoices you sent from Exhibit 3, you were invoicing every day or so, weren't you? Answer, yes, sir. Question, and none of them were getting paid, were they? Answer, no, sir. Question, you never made any effort to pick up the phone and called over and say, look, what's going on? Answer, this is true. Question, it went on for 3 months. Answer, yes, sir. And again, that's volume 15, page 56 and page 57. Then also, at page 70 of volume 15, question by me, Mr. Hedrick, you understood what the joint check agreement was intended to be with the 3 parties, right? Answer, yes. Question, to require agreement of 3 parties to change the way they had been conducting business. Is that a fair statement? Answer, the agreement is for the general contractor to understand that we need payment directly from them so we could make sure we get paid for materials. Question, but prior to a joint check agreement, the supplier, which was you, had no contract with the owner or the general contractor, right? Answer, true. Question, so you're asking to make a change that included 3 different parties, right? Answer, correct. And it required the agreement of all 3 parties, didn't it? Answer, yes. Question, and if one of those 3 parties didn't agree to it, you wouldn't have had an agreement, would you? Answer, true. And then the court questioned Mr. Hedrick, and this will be my last 40 seconds. This is at page 76 of volume 15.
Ms. Reeves, let me ask you this. Is it correct that the court on page 9 of its memorandum opinion said, it is clear that Dover's signature and transmittal of the agreement constitutes its assent?
Parties